All right, section G of the purchase contract, which is title. G1 says preliminary title report. Escrow is instructed to promptly order a preliminary title report, or otherwise known as a prelim, on the property for delivery to seller, buyer, and their respective brokerage firms. The prelim will provide a legal description of the property and a listing of the encumbrances on the property that will remain after closing. So what we're looking for on when you receive a prelim is any clouds on title, any encumbrances, as I'd mentioned, any easements that are recorded, if there's past due property taxes, and also things simply like, does the name on the contract, the purchase contract, match up to what the name is on the prelim? So, for instance, if you see, Mr. and Mrs. John Smith on the purchase contract from the sell side, and it's a bank or something like that shows up on title, that means that it's already probably been foreclosed upon, if that's the case, if it's a distressed property. If it says another party, if it says a trust, those kind of things may need an adjustment to the purchase contract to make sure those they match up. So looking at a prelim and understanding that is really, really important. So moving on to G2A title. Seller warrants that the seller is the owner of the property. Seller agrees to convey the property free and clear of all liens and encumbrances at closing, with warranties vesting marketable title to buyer. Exceptions shall include, but are not limited to, easements, covenants, conditions, reservations, restrictions now of record, and any documents relating to a condominium, co-op, PUD, which is a planned unit development, subdivision, homeowners, community association, or cluster development. So the exceptions, what they're referring to is that if you're purchasing a townhome or a condo that is in an association, obviously they record and they have nothing to do with the sale portion of it. The exception is all the rules that apply to one owner will still remain throughout any purchase going forward, because that's obviously common sense. Part 2 is encumbrances to be released at closing shall include, but are not limited to, any liens, mortgages, agreements of sale, financing statements, judgments, child support, alimony, mechanics liens, notice of pendency of action, which is lis pendens, which is the beginning of foreclosure or a lawsuit, subsidy agreements, equity sharing agreements, buyback provisions, repurchase rights, and or options to purchase shall be cleared by seller prior to closing, paid off, and either released or arranged by release by escrow. So part 2 is what that's referring to are the things that will be removed and released, which is things that pertain specifically to the seller. So obviously the seller's mortgage, the seller, if they have child support, if they have a mechanics lien, those kind of things need to be cleared at closing. G2B is buyer's review of the preliminary title report. If buyer is not satisfied with the prelim, buyer may elect within X amount of days of buyer's receipt of the prelim to terminate this purchase contract pursuant to Section 02. I would put in there 7 to 10 days. That gives them enough time to take a look at it in total to make sure that there's nothing wrong or nothing that would hinder their ability to enjoy the property and marketability on a future sale. G2C, title defects. If buyer elects not to terminate under paragraph G2B, and if the prelim or any other report or any updates to such reports reveal that title cannot be delivered by seller in accordance to paragraph G2A, then seller shall make appropriate disclosures under paragraph I2. I2 again is seller disclosure, and seller shall use reasonable efforts to cure any title defects. If within X amount of days following receipt of any report of title defects, seller is unable to cure such title defects, buyer may elect to purchase a property with such title defects, and seller shall not be liable for such title defects. If buyer elects not to accept the property within such title defects, either buyer or seller may elect to terminate this purchase contract pursuant to paragraph 03. So it's really important that you review the prelim, because if there's issues that show up on there, the buyer has the right and a contingency that allows them to exit the contract and receive their earnest money back. But if you wait too long, then they just now, it's assumed that they're going to be purchasing with those defects in place. Lastly, section G3, vesting and tenancy. The buyer is the person or entity which have signed the purchase contract on page 14. Buyer shall provide escrow with buyer's full legal name and marital status for individuals, trust documents, name and type of business entity, etc., and the tendency by which the buyer shall take title within X amount of days. 15 days if left blank after the acceptance date. Just so you know, too, it says in there in a variety of different spots, it will assume like 15 days if left blank. Don't leave anything blank. We kind of discussed that in previous videos. Just fill it in. It's much easier. It looks clear and concise. Just fill it in so that no one else will put any information in there without your knowledge.